Today, we had a privilege to have Justice SD Anand with us, and Justice SD Anand has agreed to provide us first-hand visit experiences of the justice delivery system.
Namaskar. I take it to be a great opportunity to have been given a chance to speak to you, the budding lawyers of today, upon whom falls the responsibility of projecting and protecting the civil rights, the fundamental rights of the citizens of this great country. It is not without nothing that the constitution makers, in their wisdom, declared in the constitutional documentation itself the status of the justice delivery system, the judiciary. When we talk of judiciary, we not only talk of the apex court or the high courts, we also talk of the trial courts and the first appellate courts. In my view, the trial courts and the first appellate courts have an equally important role to play in the delivery of the exercise of justicing because they are the courts of fact. Boys and girls, always remember there has to be a reason why every profession has its own importance, every facet of administration has its own importance, be it the legislature, be it the executive, be it the governmental side of it. At the same time, the justice delivery system has been accorded an appropriate placement by the constitution makers. It is the justice delivery system which not only adjudicates upon the disputes between one citizen and another, it also decides upon the dispute between a citizen and the mighty state. With the proliferation of various laws like environment and the like, there has been increase in the litigation. So be it, you are there, you are performing a religious duty when you are able to get justice for the needy or get justice for the one who deserves. Lawyers, I have always felt, have a peculiar role to play in ensuring the peace in the society. Given my obsession for the justice delivery system, I must share with you that I happen to be a fourth generation lawman. Father of my paternal father was also a lawyer. Those were the times when people would not even go to the school, quite a few of them. What I mean to say is, I have an intestamentary legacy of being related to the system of justicing. Justicing would also come into play when there is a dispute between one state and another, between the center and the state, when there is a dispute between the builder and the flat owners, it may be an unequal fight. Dispute between a rich man and a poor man, law does not recognize any level of poverty, any financial placement. Law is there to protect the rights of its citizens. For example, you say that it's not very important for the trial court to decide upon with urgency the dispute between neighbors over a wall. No, it's very important. If the dispute is decided and attains finality at the highest level, they will have peace of mind. The losing party ought to have a feeling that I've exhausted the resources available to me on the judicial side right up to the curative level. And it means that I did not have a good cause. Disputes between estranged couples about their matrimonial status, disputes about the custody of children have equal importance. The disposal of such like matters must come about at the earliest. All these are different facets of justice delivery system. Let the other organs of the government of the state perform their own duty, while the justice delivery system, in the form of the temples of justice, they perform their own. You are officer of the court. While you represent the parties which have engaged you, you are also there to maintain the ambience of justice here. Be reverential, be respectful. Do not insinuate. Attack the judgment on point of law. Attack the judgment if there is an error about the factual accuracy of the facts having been noticed in a judgment. You are the blessed lot when it has fallen to your destiny to be a part of the justice delivery system. The author of today's roster, Dr. Kapoor, has been a part of the justice delivery system, initially as a member of the bar and then as a judicial officer. He did his job exceedingly well, and it's a great favor that he wants to share with you the ingredients of offenses. Do not feel any hesitation in picking up the book when you are into the drafting of readings, whether on the civil side or on the criminal side. Listen to Dr. Kapoor. He is going to share with you something very meaningful which will help you in good stead. All my best wishes to Dr. Kapoor in the exercise. My gratitude to him for furthering what I conceive to be his contribution, my contribution, the contribution of every independent mindset towards the facilitation of the justice delivery system. Thank you.
Thank
Jai Hind.
you. Thank you very much. These words of wisdom and this experience will provide us deeper insight. And it is in the light of this insight that we have to have a fresh visit to the provisions of law. Let us now start the visit which we are continuing. We are visiting the trial procedural steps. Of it, the first initial basic foundational step is of framing of a charge. The framing of charge takes us to the ingredients of the charge, means ingredients of the offense. Therefore, we shall have more concentrative visit to the ingredients of an offense. There are certain offenses which are interrelated and they may be taken as a chain. Today, I want that we shall visit to Section 34 IPC, Section 149 IPC, Section 120A IPC, Section 120B IPC, Section 10 of Indian Evidence Act, Section 107 IPC, and Section 196 Code of Criminal Procedure. I am taking these 7 offenses as a group from the point of view of having distinct features imbibing of the ingredients of the offenses. Section 34, Section 149, Section 120A, Section 120B, and then Section 107 or the Indian Penal Code offenses. These offenses as such are in a graded phases like the intention, meeting of mind, then acting in furtherance of the meeting of mind, and then there being some sort of an agreement to commit an offense or to do lawful thing by unlawful means, and it is in respect thereof that Section 10 of the Indian Evidence Act has a specific legislative mode of leading evidence, having relevance of an evidence, and Section 196 Code of Criminal Procedure also has certain restrictions and conditions and framework within which the offences of conspiracy with respect to particular stages, particular ranges, particular the the punishment quantity, and that being so, we shall read these sections one by one and imbibe as to how that a shift from one offense to another offense is having one or more additional features over the other offense. Section 134 IPC states acts done by several persons in furtherance of common intention. Therefore, if there are more than one persons and some common intention of those persons is there, then in that situation, the act done by any one of them is attributed as to the other persons also who had joined with the persons acting. Now, this section, when a criminal act is done by several persons in furtherance of common intention of all. So here the focus is common intention of all. Now, it is a very delicate feature how to infer whether or not one person is having common intention with other person. So focus here is upon the common intention of all, and each of such person is liable for that act. Therefore, we have to pose to ourselves as to how common intention is to be inferred. Now see section 149 what it says. Every member of unlawful assembly guilty of offense committed in prosecution of common object. So previously in section 34, it was a common intention. And in 149, it is a membership of unlawful assembly. So unlawful assembly is to be defined. Unlawful assembly ingredient is to be appreciated. Membership of that unlawful assembly is to be inferred. And then if offense stands committed by that assembly, then guilt is to be taken as if it is of everybody. Now, difference between 34 and 149 in practical terms is that for unlawful assembly we shall have 5 persons or more. But here there may be 2, 3, 4 or 5. So what normally happens is that when any group of persons are put up on trial, say of a murder, then section 34 is normally becomes complementary of that state when the persons are less than 5. And 149 takes us that if the persons are 5 or more. But however, this only is not the difference. The difference is in section 34, a common intention, and in section 149, being a member of an unlawful assembly and offense committed by common object. So it is the common object here which is a focus. The section 34 focus, the feature is common intention, and the feature of 149 is twofold. Firstly, being member of unlawful assembly, and secondly, there is a prosecution of the common object. So membership and object, membership of an assembly, and then the common object of that assembly are the two features. See, from common intention to the common object, a very delicate type of difference is reflected. Now, see, if we go a step ahead, then Section 120 AIPC, see what is the definition of a criminal conspiracy? When two or more persons agree to do, so Section 34, we require two or more persons. Unlawful assembly, it is two or more, that means we exceed five as well or up to five as well. Therefore, when two or more persons agree to do or cause to be done, so it is not only that one is himself to do a certain thing, he can cause the same to be done by other persons or by other means. Therefore, here the ingredient will be there would be two or more persons and they have agreed. So here is the agreement. The two persons are agreeing. So see, in Section 34, requirement is common intention. In Section 149, the requirement is being a member of unlawful assembly and act having been done in for the common object. So when we come to Section 120 AIPC, here there should be an agreement. Now this agreement is an illegal act. So the agreement of the persons is to be for doing an illegal act or act which is not illegal by illegal means. So see, here in Section 120A, the definition of conspiracy, the requirement is of two or more persons. Secondly, those two or more persons to agree, there should be some sort of an agreement between them. And thirdly, that agreement shall be for doing an illegal act or doing legal act by illegal means. So see here, it is the legal acts done by illegal means is also an offense which is false, which is covered by the definition of criminal conspiracy. Section 120B is just providing a punishment for criminal conspiracy. So while we will be appreciating the ingredients of offense 120A, then the first ingredient will be there should be two or more persons. Second ingredient will be there shall be an agreement between those two or more persons. And the third thing will be that agreement shall be for doing an illegal act or doing legal act by illegal means. So let us reread, let us revisit Section 34, Section 149, and Section 120A. Now, Section 120A is giving a definition of a criminal conspiracy. So, criminal conspiracy here is being made an offense in itself simply if there is an agreement between two or more persons for doing an illegal act or doing legal act by illegal means. Such an agreement is designated as a criminal conspiracy. So here is the definition of a criminal conspiracy. Now see, 120B, what it says: whoever is a party to a criminal conspiracy to commit an offense punishable so and so, so and so. So, definition of criminal conspiracy in itself is not elaborating as to the agreement of illegality or legal acts to be done by illegal means is being designated as a conspiracy. However, there is a proviso in section 128 to the definition, provided that no agreement except an agreement to commit an offense shall amount to criminal conspiracy. And further, unless some act besides the agreement is done by one or more persons to such agreement in pursuance thereof. Now see, the criminal conspiracy is between two or more persons. This is when they agree. The agreement is to be for an illegal act or an act which is not illegal by illegal means. And then this agreement itself is being designated as a criminal conspiracy. See, the broader frame of this definition is that there remains an agreement between the parties. It is a mental state of two persons. Two persons are in a mental state agreeing, simple agreeing to do an illegal act or to do legal act by illegal means is defined as a criminal conspiracy. However, to this, there is an exception, there is a proviso, and the proviso is that no agreement except an agreement to commit an offense. Therefore, the definition comes to be when there are two persons, they agree to commit an offense. Two persons, when agree to commit an offense, only then, otherwise no agreement except an agreement to commit an offense. So while we will be appreciating the ingredients of the offense of criminal conspiracy, it will in practical terms come to be, number one, there should be two or more persons. Number two, there should be an agreement between those two persons. And then that agreement shall be, firstly, for doing an illegal act. Secondly, it shall be doing legal act by illegal means which is not illegal to be done by illegal means. However, still the proviso has been added to make it more specific that even if there is an agreement to do an illegal act, and if that illegal act may be having civil ramifications, if it is not declared as an offense, then it will not be criminal conspiracy. It may be anything. It may have any civil implications, but it will not have a criminal implications as yet it has not become an offense. Criminal conspiracy is an offense. It is an offense by two or more persons agreeing to do an offense. So, for having determination of the ingredients of section 120A, we have to reach at the offense in respect of which there is an agreement between the persons. So ultimately we have to visualize, we have to reach at the offense. What was that offense which has been agreed to be committed by those persons? Now visualize and pose to yourself whether there can be an offense which has not been made illegal, or whether there could be a situation of an agreement where not illegal is also not illegal by doing illegal means. It's a big theoretical academic analysis thereof, but in practical terms, the aspect comes to be that there should be 2 persons or more, there should be an agreement. No, how to reach at that there is an agreement or not? It again is a mental state also in most of the situations. So, common intention of section 34, common object of 149, and the common agreement of section 120A are graded situations. Therefore, we have to be sensitive, we have to be conscious, we have to be specific while to reach at the ingredients of the offenses. And it is in terms of the ingredients only that it will be said the offense stands committed and the charge is to be framed and accused to be put upon a trial. Now, a step ahead, it is provided in section 107, abetment of a thing. A person abets the doing of a thing who first instigates any person to do that thing, or secondly, engage with one or more other persons or persons in any conspiracy for the doing of that thing. If an act or illegal commission takes place in pursuance of that conspiracy and in order to doing of that thing, or thirdly, intentionally aids by an act or illegal omission the doing of that thing. See, how many shades are there? How many degrees of addition over the initial foundational step is there? So there are many steps of this ladder. So while appreciating the ingredients for having distinctive features of one offense from that of other, we have to approach in this concrete situation of this set of offenses, this set of provisions, 34, 149, 120A, and 107. Now see what procedural codes are having relevant provisions in respect thereof. The section 10 of the Indian Evidence Act is one act, one section which provides what are the relevant circumstances. And the Code of Criminal Procedure in section 196 provides prosecution for offenses against the state and for criminal conspiracy to commit such offenses. Now, it is here where some restrictions have been put, and these restrictions are to be appreciated while we will be making submissions at the stage of point of charge. We will take up these aspects in the next session. Thank you very much.